Hi, this is Patrick Conroy, and we're Chapter 17 Trial. Right now in New Orleans, we're getting ready for an Arctic blast, so my house is full of plants. Okay, here we go. Distinguish between evidentiary and non-evidentiary phases of a trial. Pretty simple. The evidentiary phase, that's the phase of the trial where testimony and evidence are presented to the jury or judge. So they call up witnesses, they show presentations to the jury. You get the idea. The non-evidentiary phase or phases are phases of the trial that include the early proceedings, such as jury selection, and concluding events such as the jury deliberation, jury announcing the verdict. Everything that is not considered the presentation of evidence trial is non-evidentiary phase. Okay, the early proceedings for the trial. First, there's the final pre-trial conference with the judge. And the judge and lawyers will discuss how trial will proceed and explain the time constraints. Because, you don't have an unlimited number of days so that you can present your case. There's the final instructions on jury selection or evidentiary matters. These are things that can be appealed. Final pre-trial, facilitate communication between judge and counsel and streamline the trial process. Trials are expensive for the state and for the people involved in the trial. So we want to make it as streamlined as possible. We don't want to waste the court's time, things like that. Okay, jury selection. Now the jury is going to hear the dispute, and they're going to take instructions on the law and render a decision. First, you have to select your jury, and that process is called voir dire. And in the process, prospective jurors are asked questions by the judge or attorneys to discover their bias towards one side or the other. For instance, somebody that has had a similar experience happen to them are more likely to rule in that person's favor. Say there was a hurricane and somebody's suing their insurance company because they didn't cover their losses. Well, if that trial is being held in South Louisiana, there might be a lot of people who have that same experience. So the questions are designed to expose bias or prejudice that might affect impartiality. Sometimes you want to low partiality. Okay. So some of the sample voir dire questions can be like, do you know these people being involved in the suit personally? And do you know the attorneys? What the lawsuit's about? Have you had a similar experience? Are you a doctor? Do you work in a healthcare profession? Sometimes they ask, are you a lawyer? Do you have a legal education? Now, you can challenge prospective juries for a couple of things. There's challenges for cause. And that's where the answers to the voir dire questions indicate bias. They know somebody, one of the parties, they can be challenged for cause. And there's no limit to the number of jurors that may be excluded for cause. So if you want to get somebody off, you want to do it for cause. Because with other things, like you just don't think that the right demographic for you, you're going to be based at 3 for civil trials in Louisiana. And those are called peremptory challenges. And the attorney doesn't have to state a reason. They just say, we want this person excluded. And the number of juries, it varies depending on where you are, which kind of court you're in, and if it's a civil or criminal case. And in criminal court, whether it's a capital offense or just a regular felony. Jury charge. Those are the instructions to the jury given by the judge at the beginning of the trial to describe how the trial will be conducted or they can be at the end of the trial to inform of the law to be applied in the case, or both. Sometimes this is what gets appealed. They're going to say that the judge gave incorrect instructions to the jury. Early trial proceedings does the opening statements. Okay, opening statements are crucial because you only have one chance to make a first impression. And a lot of those jurors, they're going to base their opinion on how they feel about the attorney. And does the attorney seem well prepared? Do they seem confident in their case? So it's the first opportunity for the attorneys to address the jury and describe the nature of the lawsuit. As I say, it can be crucial to success or failure, and it does give jury a brief background of the case. The opening statements, they get the attention of the jury, and they encourage jury's interest in the trial. You want them to be paying attention if you've got a lot of good evidence. And establishes rapport and credibility with the jury. This is essential. They don't think the lawyer's credible, they're not going to buy into their case. And must be limited to the facts at issue. Okay? And that's short, but we're going to wrap this one up and pick up with learning objective 3 in the next presentation.